Thank you for joining us for today's session, where we'll be looking at scoping the retainer and looking at key issues for residential conveyances. My name is Stephen Smith, and I'm delighted to be joined, as always, by Ian Quayle and my colleague Robert Kelly. Good morning to you both.
Morning.
Morning. Morning. But just before I hand over to Ian, I'd just like to go over a few items so you know how to participate in today's event. I'm sure a lot of you have been through this before, so it just takes 30 seconds here. You're listening by default in your through your computer speaker system. If you prefer to join over the telephone, you can just select the telephone option in the audio pane and the dial-in information will be displayed, and this is toll-free as well. You will have the opportunity to submit text questions to Ian by typing your questions into the questions pane of the control panel. You can send in questions at any time during the presentation, and we will collect these and address them at a dedicated Q&A session at the end of today's presentation. You can also raise your hand during the presentation if you're having any difficulties with sound or other technical issues. I'm no IT whiz myself, but I should be able to speak to you over the chat and hopefully resolve any issues that you're having. Finally, we will be including notes for today's session in the notes section of your control panel. They'll be available in around 5 to 10 minutes. And we also have links to our YouTube page where you can find other presentations we've held previously. Anyway, without any further ado, I will pass on to Ian for the main part of today's presentation. Thanks, Ian.
Thanks very much, Stephen, and welcome everyone, and thanks for coming along. I was just saying to Stephen and Robert that it's been a bit funny this last sort of week or so, obviously due to Queen, etc. And as far as work is concerned, I'm noticing a little bit of a steadying. I wouldn't say it's quiet, but it's a steadying, and I'm putting that down to the unusual circumstances, obviously surrounding the Queen's death, funeral, and all the ceremonies, etc., that go with it. So I'm very grateful for people spending their time with us today, because I know that with the bank holiday coming and everything else, we're sort of ramping up with work rather than quietening down. The purpose of today's webinar is to look at how we scope the retainer, what we do, and I'm going to be looking at some case law, some fairly recent case law in particular, about the impact of that case law on scoping the retainer. The important thing, I think, to understand from a residential conveyancing perspective is that it is absolutely essential that we tighten up what we say to clients about what we're going to do, and also something that I've bleated on about for a long, long time, we also make sure clients are aware of what we're not going to do. There's a little bit of comfort, I think, that we can extract from an unreported case, and we can also extract, I think, some comfort from some cases, in particular the Withers case that was recently heard in the Court of Appeal. We'll be looking at those too. As Stephen mentioned, if people have questions at the end of the presentation, I'll try and ensure that time is made available to answer questions. If there isn't sufficient time, I'm more than happy for you to drop either myself or Stephen or Robert Kelly at Stewart Title a note, and I'll endeavour to answer any questions that are for me. And I'm sure there may be questions for Stephen and Robert with regard to Stewart Title products, in which case, of course, the questions can be directed to them. And before we start, a massive thank you once again to Stewart Title for supporting CPD training events such as this on behalf of conveyancers generally and residential conveyancers in particular. So, first thing to do with regard to the scoping the retainer, there are lots of useful websites. One of the things I think we should be doing in specifying what we're going to do and not what we're not going to do is also ensure that our clients are aware of resources that are out there that can assist them and provide guidance with things that we're not going to be telling them about. So, for example, if in connection with boundary issues or boundary problems, Property Protocols has a boundary dispute protocol that provides assistance for clients and indeed lawyers as to how to deal with boundary issues. On that point, over the summer, I've been doing some consultancy work for a property company that's currently in dispute over a sort of tiny parcel of land that divides a development site from a neighbouring residential property. And it's staggering, really, when you look at the legal costs that could be incurred. We're talking about sort of £70,000 to £80,000 for a relatively simple county court action. And that's up to trial, not including trial, which is pretty staggering, to be honest with you. One of the things you must do with regard to leasehold transactions is again explain to clients the bigger picture with regard to leasehold transactions. I was talking about CQS guidance just recently and emphasising the fact that the CQS, like other organisations, including the SRA, encouraging lawyers to make sure that leasehold purchasers are aware of the bigger picture with regard to leasehold ownership. And again, as far as the retainer is concerned, as we'll see a little later, there are things that we should not be offering advice upon, indeed not offering explanation of, but highlighting to the client that there are resources that can be used in order for the client to gain assistance in areas such as the reasonableness or otherwise of service charge, etc. More on that a little later. We're going to talk about surveys and valuations, and again, I apologise for those of you that have heard me speak before, but the RICS Consumer Guide to Survey and Valuation is again a very useful piece of material that you can provide to clients so that you can safely say that you can't give clients advice about valuation issues or about the state and condition of the property that is being acquired or being sold. But if you're acting for a purchaser, the RICS Consumer Guide to Survey and Valuation provides the client with all the information that they need to make a reasoned decision as to what sort of survey or valuation they're going to choose. And where they don't choose a level 3 survey or a level 3 valuation, you can highlight to the client the risks associated with obtaining a lesser survey or a lesser valuation. Association of Residential Managing Agents, again, a useful site on the basis that it has a leaflet about leasehold ownership, and indeed it has a leaflet about estate rent charges. I don't know why an Association of Residential Managing Agents, which predominantly deals with leasehold schemes, is producing information on estate rent charges. The only reason I can think is that managing agents are now being asked by developers and builders to look after freehold developments where there are estate rent charges, and managing agents perhaps are the appropriate people to manage those developments and manage estate rent charges going forward. On that point, just something again that's happened this morning. Someone was emailing me about a situation where on a new development, the developer has built roads predominantly out of block paving, constructed all sorts of play areas, etc., created all sorts of ponds, predominantly for wildlife, but also for rainwater runoff purposes. And the cost of all of that is being transmitted to freeholders by way of estate rent charge. And again, just as a warning to all practitioners, estate rent charge payers do not have the same protection currently as a leaseholder would if that was a leasehold development and a service charge was payable. Finally, I mentioned Property Law UK, which again has a lot of information about some of the negligence claims that we're going to be talking about today and what causes negligence claims too. That is a subscription service. All the other sites are free to access. So the first thing I want to talk about in connection with scoping the retainer is to make sure that we understand some fundamental principles with regard to our relationship with clients. I think now it's settled by CQS, by SRA, and indeed everyone else that it is imperative that we identify client objective. Also, as we'll see from the case law that we're going to be looking at before we finish today, I think it's also important that we have some knowledge of who our client is and what their attitude is to risk and what their knowledge is with regard to conveyancing transactions. Certainly where we've got experienced clients that are not risk averse, the law seems to be that the attitude with regard to scoping the retainer can change as a consequence of the stance or attitude of commercial clients. Whether that would be applicable to a residential client that was experienced as opposed to inexperienced is a different matter. But I do think it's important that we differentiate the types of client that we're acting for and don't have a sort of common system or a common approach for each. I think that's one of the things, again, we can take from CQS guidance, the changes to guidance in May, the idea that clients are individuals and that we should be undertaking risk assessments with regard to property fraud, with regard to AML, with regard to SDLT issues for each and every client rather than having a standard policy. One of the things I always say when we're talking about reporting on title, communicating with clients, is the idea that in essence, our role is to do three things: to provide information, to provide explanation where we're capable of giving that explanation, and to give advice where we're capable of giving advice and where the advice is appropriate. In scoping our retainer on receipt of instructions, we can govern and regulate the relationship in that we can explain to the clients what information we will be generating, in what circumstances we will be explaining that documentation, where we're not explaining documentation or information, who could or what resources could be used to assist the client. And then finally, with regard to the provision of advice, we need to make sure that we're giving advice only on those issues that the retainer requires us to give advice. One of the things I think is the theme of today's presentation from me is the fact that once we've scoped our retainer at the start of the relationship, we need to be very careful about monitoring the retainer and monitoring the relationship. And where we have situations where we're giving advice, we're providing information or explanation outside the scope of our retainer, we need to vary the retainer so we're quite clear and the client is quite clear as to what we're going to do and what we're not going to do. Certainly, some of the case law that we're going to look at later has arisen as a consequence of a bit of vagueness or ambiguity with regard to the original retainer or circumstances where there has been work that's done that's gone beyond it. And whilst some of the case law has been very supportive of the legal profession, I think just alluding on to the point I made a little earlier, getting embroiled in litigation in any event can't be seen as successful. Even a successful claimant or a successful defendant isn't, generally speaking, going to extol the virtues and benefits of litigation and look at it as a sort of positive event rather than a sort of least waste case scenario in the event of winning. So the idea of scoping the retainer is that we're going to identify the contractual relationship that we're going to have with our client. We're going to limit the potential liability for a breach of contract claim, and we're also going to limit the potential for a negligence claim if we ensure that we do the right thing when the retainer is specified at the beginning of the transaction and assuming that we're capable of monitoring things as they progress. So let's have a look at some key issues then. There are notes, as Stephen mentioned, that accompany today's presentation. So a lot of the detail as to the points that I'm going through are contained within those notes. What should the retainer deal with? Well, from a purely selfish perspective, it should reduce or limit our potential liability for claims, no matter what the claim is, contractual or in tort. It should highlight the work that we will be doing. It will also highlight the limitations relating to the work that is to be done and highlight work that will not be done. Now, I have to say that this issue of what we're highlighting as to do and not do and the limitations of what we're going to do will depend from transaction to transaction and will also depend on the type of client that we're dealing with. But here I can give you the first sort of crumb of comfort, if that's the right term. Certainly what the courts are saying in an unreported case just recently is that if a client is paying a relatively low amount for the conveyancing services that you are providing, you are perfectly entitled to limit the work that you're going to do. And in highlighting the limitations of the work to be done and highlighting the work that won't be done, you are protecting yourself. So in this particular case where a client was paying a relatively low sum for a conveyancing transaction, the court did take into account that fact and was of the view that the client could expect a minimum level of service. Now that runs entirely contrary to what I've been saying to practitioners for many years now. Namely, it doesn't matter what you charge the client, the duty that you owe to the client, the level of service that the client can expect is the same. I think there's been a change in shift with regards to that. There's been a shift in judicial attitude. And the important point, I think, is that in scoping the retainer carefully, if you are undertaking conveyancing and offering low fees, you can inbuild additional protection. In the past, I would say that wasn't possible. I'm now beginning to form the view that it certainly is possible these days. This issue of highlighting work that isn't to be done or explaining the limitations of the work that you're going to do runs contrary to sort of good marketing, doesn't it? You know, the idea is we should be telling clients how good we are and how all-encompassing our work is. But to be protective of yourselves, I think you've got to be realistic and making sure that clients understand from the outset what is going to be done and not to be done. This is something, again, I was speaking to someone last week about. Deal with a number of firms that have sort of sales teams or marketing teams or onboarding teams. that are sort of welcoming clients or encouraging clients to instruct the firm, and then fee earners are actually dealing with the conveyancing work. And one of the things that I see on a fairly regular basis is a mismatch between what the sales or onboarding team are saying to clients in order to encourage the client to use the firm, and then what the fee earner is actually saying once they've had a look at the transaction, once they've got agents' particulars, and once they've seen title. So again, whilst we should be ensuring that we regulate the relationship with the client by providing them with terms and conditions of trade, by providing them with a scoped retainer, there is a danger in doing that too early without having looked at the client's needs, ascertained client objective, and had a look at the work that is likely to be required to be done given the transaction. So let's focus in on the retainer for a little while. Should the retainer be in writing? Definitely. The courts are saying that you can have a retainer that is oral or implied, but the problem with that, and there's lots of judicial statements on this, that you are exposing yourself to vulnerability where there is a confusion as to what is to be done or what isn't to be done. And certainly within the notes, I mentioned the old case of Griffiths and Evans, 1953 case, where Lord Denning was sort of anxious to make sure that people understood that the role of the solicitor is a specialist role, that generally speaking, there isn't a case of a solicitor dealing with all matters on behalf of a client, unless the solicitor has agreed to that. But the danger is that where there is an oral or implied retainer, there's a danger that where the word of the solicitor is against the word of what the client is saying was or wasn't agreed, or what or wasn't done, the client is likely to be preferred over what the solicitor has to say. And Lord Denning said in that case, the general principle is that a solicitor is the agent of his client in all matters that he may be reasonably expected to arise for decision in the cause. In saying that, what he is specifying is that if a solicitor doesn't take the precaution of creating a written retainer, he's got himself to blame if there is some misunderstanding or some variance as between what the conveyancer or solicitor thinks is going to be done and what the client thinks the solicitor is going to do on their behalf. As far as the stance of the courts are concerned, then I think where you have a robust retainer, in particular setting out what you're not going to do, the court will be very supportive. Where you are highlighting to clients the limitations of the work that is going to be done, again, you've got the same protection in most cases. So the stance of the courts is quite interesting. As far as the 53 case that I've just mentioned is concerned, there are later cases where you can find good evidence, good examples of retainers being quite tightly controlled and managed, contained in documents that are clear and concise, where there are clear lines between what is included in the retainer and what is not. So I think the takeaway from today is just have a look at your retainer, ensure that you are telling clients what you're going to do, make sure if there are limitations with regard to what you're going to do, that the retainer highlights that, and make sure the client is aware of what you're not going to do. So let me just look at that for a moment or two, and let's put some examples out there for consideration. As a residential conveyancer, you're going to be acting for a buyer. You're going to be telling the client that you will be undertaking searches. What is your duty with regard to search results? Well, the duty is to explain to the client what the searches reveal. It is not enough simply to send a copy of the search results to the client to say, have a look at that. It would warrant some explanation as to what the search results reveal, where those search results impact on client objective, where those search results are adverse to the client, the transaction, or the objective, then some advice needs to be provided. In highlighting the limitations of the work that you're doing with regard to searches, I would do two things. Firstly, explain to the client that the search may not in fact be accurate. There are occasions when searches are produced that are defective and that isn't your fault, but there is some protection with regard to state guarantee, local authority liability, whatever it may be, search provider, professional indemnity insurance, this sort of thing. The second thing that I would do is explain to the client that the retainer involves you in obtaining search results, advising clients as to search results, highlighting or identifying risk, but as far as going on to not only identify the risk, but assess just what the risk is, then we might draw the line and say that we're not going to make any assessment with regard to risk. It may be necessary for specialist advice to be sought where there are adverse entries or where there are entries that will impact on the client's objective. If we look at a situation where we're obtaining searches, we should explain the limitations with regard to searches, so a local land charger search doesn't carry any form of priority and is out of date the moment the search is undertaken. With regard to other aspects of the retainer, surveys and valuations, we can advise a client that we'll always recommend a survey or valuation. We'll advise our client to obtain the best survey they can afford, highlight the benefits of a level 3 survey and valuation, but then explain to the client that as far as the survey or valuation is concerned, the only aspect of the survey or valuation that we will consider will be those issues that the surveyor or valuer has identified that refer to title. So what we're doing there is telling the client what we're going to do, explain to the client the result of what we're going to do, and then explaining to the client the limitations with regard to our work. Now, let me give you a third example before we move any further. Overriding interests. In a standard conveyancing transaction, the only way that you as a conveyancer will be aware of an overriding interest is if the seller discloses it, and the seller would only be obliged to disclose anything that was a latent overriding interest, not a patent one, or if your buyer client or the surveyor or valuer becomes aware of it during inspection, or if the seller or the seller's conveyancer simply volunteers it. But you as a conveyancer are entirely dependent on any of those third parties reporting to you or disclosing to you the existence of an overriding interest. Without it, you're blind, your client is bound by something that you are unable to report on. Again, the client needs to be aware of that. Client inspection flowing on from that, important that the client understands that you won't be inspecting target property and that you will be relying on client, surveyor or valuer to report to you anything that is essential that you are aware of, that you ought to be aware of, relevant to that inspection. With regard to retainers, do make sure that you watch out for vague or ambiguous wording, so the client is quite clear as to what is being done and what isn't being done. Again, an interesting point with regard to the retainer, what about advice on co-ownership? Again, I would always explain to a client that I'm required to give advice relating to co-ownership, but I'm dependent on the client or clients giving me instructions as to what their actual contributions are and what their wishes or intentions are, and that I can then give advice on the basis of the circumstances surrounding the intended purchase and the client's wishes relating to co-ownership. Again, important, as far as the retainer is concerned, it is absolutely essential that what we're doing is making it quite clear as to the line that's drawn between what we're going to do and what we're not going to do. The court will infer the situation where additional work is required, where our retainer is vague or ambiguous, or where we are doing things for the client during the life of the transaction outside the scope of the original retainer. So again, I think it's important that we have a policy that states that if a fee earner is required to do tasks beyond the scope of the retainer is varied before that work is done. And again, lines are drawn and the positions set before we do anything else. So this involves management and monitoring the retainer. And again, that's the responsibility of the fee earner. And as far as that is concerned, the firm can have policies relating to what the standard work is that would be undertaken will be, and where there will be non-standard work which would require an expansion of the retainer. Again, there may be circumstances where we're not expanding the retainer, but in fact we are restricting or limiting it. So for example, if our client starts suggesting that they're going to do construction work to a residential property that is being acquired, I'd make sure the client is aware that we will not be giving any advice with regard to any issues with regard to construction. The client is submitting a planning application or any of that nature, unless we're assisting or our planning team is assisting with that work. Again, I would be making sure the client is aware that and reminding our client of the existing retainer, or the fact that we are limiting or restricting the advice that we're giving relating to the additional work that the client is undertaking. I think it's important that we deal with the retainer on receipt of instructions or as soon as possible at that point. But again, I would maintain the view that it is essential that we keep the retainer under review, and it's essential that our fee earners are aware of the fact that we are quoting for and we are agreeing in the original retainer as to what we're going to do, and there may be circumstances where that needs to be refreshed. I've mentioned some case law in the notes, a case called Midland Bank against Het, Stubbs and Kemp, which is 78 decision. And again, the important point here was that the claimant in this case, the client, was trying to say, well, the solicitor was more than just a conveyancer. They were sort of a project manager, and they were under some form of general retainer to assist us. And they're all right. A residential conveyancer wouldn't normally give advice about the registration of an option as a land charge. But in this particular case, the work that the conveyancer or solicitor was doing was far more general than being a transactional property lawyer. And again, to prevent yourself becoming embroiled in that sort of situation, it's your responsibility to make sure the client is aware, I repeat, of what you're going to do, but also of what you're not going to do too. So let's just go a little further if possible. So what should the retainer include if we act for the seller? Well, what I've done in the notes is giving you some examples of the sorts of things that we might do if we're acting for a seller. So for example, I'm just going to dig my notes up for a moment. Again, we might be telling the seller client that we're going to consider the evidence of their title. We're going to review that title and audit it. We're going to look at the estate agent's sales particulars, which we'll consider. We'll call for, where appropriate, an EPC. We'll look at the seller's title. We'll make sure the seller is producing the appropriate TA forms, etc. But again, with all of that work, we should be telling the client the things that we're not doing. So we're not going to be able to give our seller client advice as to whether the sale price that's been negotiated is good, bad, or indifferent. We're not going to be giving clients information or advice where there's negotiation for a price reduction or anything of that nature. We're not going to be giving clients advice with regard to how they complete the TA forms or what they say in the TA forms, other than we're going to check what the seller says when the TA forms are returned to us against the information that we've got on our file. If we're acting for a buyer, again, we should make it quite clear as to what we're going to do. But again, as to what we're not going to do, we should make sure that the client is aware that we're not going to give advice about the state and condition of the property, whether the purchase price is good, bad, or indifferent. There are limitations as to the work that we can do with regard to search results, clear searches, or adverse entries. There are issues with regard to client inspection, issues with regard to whether or not the mortgage offer that the client is proceeding with, again, is good, bad, or indifferent. We should be making sure that the client understands that we're recommending survey and valuation, environmental search and report, drainage and water search, etc. But we are not sufficiently qualified to be able to give advice relating to the results of the searches that are undertaken, and that the client should be seeking specialist advice if there are any issues that require clarification relating to those searches. So I've given you a flavour of the sorts of things that I think should be excluded from the retainer when acting for a seller or buyer. But the point I want to emphasise, if I may, is that each case turns on its own sort of facts and circumstances, and each client might have different needs, different requirements, and therefore we should have a standard form of retainer, standard terms and conditions, but we should be alive to the fact that certain transactions require us to review or revise them. I think this is an interesting thing with regard to conveyancing generally, an interesting thing for general debate too. You know, as the conveyancing process becomes more and more standardized, as sort of systems and processes are devised or software created for us that enables us to become more systematic, that frees up time, and that time that's freed up should mean that we're able to spend more time on making sure that our clients are receiving a personalized service. I think that's where the big gain will come with regard to the use of artificial intelligence, the use of digitalization, etc. Yes, it will enable us to do more work. It will also enable us to work better, and in particular with regard to this communication with clients, so that clients understand what our role is as a conveyancer. The standard relating to that sort of communication and the information that we're providing to clients should increase. Moving on, if I can then. I mentioned in the notes about setting realistic client expectation. And I think as far as that is concerned, again, we should be giving clients examples of the sorts of things that we will be doing and not doing. So in the notes, I mentioned that the retainer should contain information about our availability of professional indemnity insurance cover, the fact that the conveyancing process isn't necessarily always going to run smoothly, and what is available where it doesn't run smoothly. The fact that we might be outsourcing work with regard to our searches, we might be outsourcing work with regard to reporting on title, etc. We should be telling clients in our excuse me, in our communications with the clients about the availability of limitations or restrictions on liability in connection with the work that we do. So again, we're trying to make sure that clients understand and appreciate the conveyancing process. In short, when we talk about realistic client expectations, I think we have to do a number of things. We have to explain the limitations with regard to our role. That's what the retainer does. We need to explain to clients what the conveyancing process involves and what we expect the client to do and what they can expect us to do. And we should also make sure that the client understands and appreciates that there are issues with regard to the conveyancing process where we are reliant and they are reliant as a consequence on third parties. So I've given you information in the notes about all of this in a lot of detail, so I needn't worry myself too much about that. There is an issue, however, with regard to informed consent. A client can only agree to the retainer if they understand what the retainer is attempting to do. So where we're limiting liability, where we're highlighting what we're not going to do, or the limitations of what we're going to do be careful about the wording that we provide. Do make sure that it is quite clear in layman's terms as to the process and the aspects of the process that we will be dealing with and liable for if something goes wrong, and those aspects of the transaction where this will not be the case. So again, I go back to this issue about the provision of information, the provision of explanation, and making sure that information that is provided in a way that the client can understand. So if we are scoping the retainer, producing a written retainer, which may or may not also include our terms and conditions, it's important that the client reads that document, understands it, and confirms both of those things. So where we are sending a retainer to the client, where we are advising our client of what is to be done and not to be done, I want to see that the client has acknowledged receipt of that communication, has read that communication, and has understood it. So that if challenged at a later date, we can at least say that we did all within our power to make sure our client understood it and was aware of it. And one of the things we can do, and I mention this quite frequently in all of my presentations, is in our emails and communications to our client, in the conclusion of the communication, say to the client, unless you tell us to the contrary, we will assume that you have read this document, that you have understood this document. And unless we hear from you to the contrary, we'll assume that you don't have any questions or queries in that connection. I think in doing that, we're appearing to be reasonable. We're giving the client the opportunity to own up when the information is provided, to say, hey, I've got questions, or I don't understand what you're saying or trying to do. I want to emphasize again this very important point about not just simply providing a retainer at the start of the transaction, then just letting the transaction drift along and progress no matter what. It is absolutely essential that we do think about circumstances where what we're being asked to do is pulling us away from what the retainer set out, that which we were going to do. So again, the sorts of things that might happen, unless in our retainer letter we're setting out about, for example, the obtaining of effective title insurance policy, where a defective title insurance policy is required, we should make sure that the retainer is varied to explain what we're going to do with regard to defective title insurance. In situations where the title that we've had offered to us from the seller is particularly complex, again, an explanation to the client as to that complexity and the fact that our retainer requires varying in that we've got to deal with a possessory title, we've got to deal with a dispute with a neighbour, we've got to deal with an unknown restrictive covenant, or we've got to deal with an easement that probably isn't sufficient to enable our client to achieve the objective with regard to the land or property that is being acquired. Moving on, if I may, the report on title must not be confused with scoping the retainer. Again, I'm doing lots and lots of work on reporting on title at the moment for companies that are coming up with systems and artificial intelligence that enables reports on title to have data automatically migrated to them. And to an extent, I think it's a great idea, provided that we use it as a tool and we don't see it as a means of enabling us to sort of wash our hands of the need to report on title. I think it's a measure, it's something that will assist us, but it won't take over the important role of reporting on title to clients, for the reason that I mentioned a little earlier, the fact that clients require a sort of personalization and require us to give an expert view as to issues relating to the title that's being offered by the seller and how what is being offered will impact on objective. So a report on title will not scope the retainer. It's too late when the report on title is produced for that to be done. It will or may contain limitations and exclusions with regard to the advice or explanation that it contains, but that's different to what the retainer does. So again, I'm concerned if firms are looking at the report on title and looking at limitations and exclusions with regard to the work that's being done on the basis that I think that ship's left port. So it's important that we deal with the retainer at the start of the transaction. We vary the retainer as and when the transaction requires it. And with regard to the report on title, I think what we should be doing is simply reinforcing to the client what we've already said, and where appropriate, limiting and excluding liability with regard to the data and information the report on title contains. So again, the point that I want to extract from this slide is that yes, we should be reporting on title to our clients. Yes, we should be explaining what due diligence has revealed. Yes, often what we are saying is in essence a repetition or a clarification of the data and information that's been received as the transaction progresses, but we should be connecting that back and ensuring it's consistent with what we're saying in connection with the retainer. Again, as far as reporting on title is concerned, one or 2 points just to clarify. The report on title is not a report to a collective client, it's a report to individual clients, and it may be necessary to consider individual clients where we're acting for husbands and wives or partners. We should be thinking about individual clients' attitude to risk, knowledge, skills, etc., relating to the transaction. Before we finish today, I want to look at a lot of case law. So if I can just find my notes for a second on the other machine, here we go. There's lots and lots of case law that we can extract, some of which you'll be familiar with, some of which you won't. But the case law does highlight a number of things that I want to share with you if possible. The first thing with regard to case law that I think is important are cases such as Orient Field Holdings Limited and Bird and Bird, which sort of emphasize the important point about searches and what we do with regard to searches. Sorry about that. I'm just speaking to you in an ante room at a conference, so there's a bit of noise coming from the room at the moment, so I apologize for that. But just going back to this point, Orient Field Holdings and Bird is a great case because it shows you what you're expected to do with regard to searches. The important point with regard to searches is that you've got to include in a report on title the search result, to provide a summary as to the search that's been carried out and what that search reveals. the important point here is that we're telling our client about issues associated with risk. So we're highlighting in this particular case about a potential problem relating to planning. We're not expected as a residential property lawyer, as a transactional property lawyer, to give our client advice relating to planning issues. We are simply required to say to the client, the search result reveals that there is a planning issue. And then say to the client, either we, if we're comfortable in doing that, or a third party, planning consultant, one of our planning team, if we have one, can give you advice about what the consequences are of what we've ascertained, what the risk is with regard to what we've ascertained. If we look at that case, one of the things that was emphasized was that when we report to the client what the search reveals, we should be inviting instructions from the client as to what they want to do. So we're offering choice. Do you want us to investigate the problem and have our planning team report to you? In which case it might be necessary for the planning team, it will be necessary for the planning team to be instructed and to have an engagement letter and to have a retainer relating to that aspect of the transaction, or is a third party going to be dealing with it? In which case, if the client says that is the case, I would be confirming to the client that that's the route that the client has chosen. In Moda International Brands against Gately, which is a 2019 decision, this was a commercial property transaction. And the interesting thing about that was the solicitor that was acting in connection with the transaction was in for some fairly heavy criticism because of the fact that there was this friendly relationship, which meant that the fairness stance and attitude was far more relaxed than it should have been. There was a lack of notes or records with regard to what was being revealed, what was being told to the client, and what the client's instructions were. There were important decisions being made with regard to the transaction that were being communicated orally between lawyer and client, and there was no evidence to support what was said in those meetings or in those telephone conversations. There was a situation where relevant documentation had not been provided to the client for the client's approval. So again, this is a case that sort of shows the potential breakdown that can arise in commercial transactions and in residential transactions as well. No matter how familiar you are with the client, if your retainer specifies what you're going to do, you need to ensure that it's done. Where important decisions are being made by you, important advice being given by you, and instructions being received from the client, again, it's important that that is documented. Again, it is important to understand that where there is a lack of evidence, a lack of sort of clarification as to issues, as to who's doing what, what's being said, what instructions are being given by the client and what's being received, there is opportunity for claim. And I think Moda International is a great example of that. Failing to keep the client informed meant that the lawyer involved and the firm involved were negligent. Minkin in Landsberg is a great case when we're talking about the retainer. And again, I've given you some detail in the notes relating to this case, but it highlighted a number of things. Firstly, it explained that a lawyer was under a duty to explain process, a duty to explain documentation, and a duty to explain risk. Not to assess risk, but to highlight the fact that there was risk or vulnerability for a client in a transaction. Where you are acting in a conveyancing transaction, it is important that you carry out the tasks which the client has instructed you to perform and which you have agreed to undertake. So if you are stating in the retainer what you're going to do, it is imperative that that is done, or the retainer is varied or altered. It is important that you proffer advice which is reasonably incidental to the work that you are carrying out. And again, that implies, doesn't it, that it's quite clear what you are doing. And it is important that you warn inexperienced clients of risks which are apparent to you, but not necessarily apparent to the client. And again, that's a really interesting case because it highlights some of the basic fundamentals relating to identifying the retainer and making sure that the work that you do is connected to that retainer, is within the scope of the retainer, in short. I mentioned MBS against Grant Thornton. The reason I mention that case is that it then flows into an unreported case concerning a firm of solicitors in Plymouth. This was a very interesting case, and I haven't seen the judgment. I've just seen articles relating to it, and I haven't got a citation for it yet. But this case, this non-reported first instance decision in the county court, emphasizes some very interesting points. Firstly, the judge said that where solicitors were taking on large volume, low-cost work such as conveyancing, they're perfectly entitled to limit the scope of their retainer. Where a client is paying less or nothing for professional service, the general rule is it doesn't alter the standard of work that must be completed. But in this particular case, the situation that the fees that the firm were being paid were so low that the firm was perfectly entitled to be very robust with regard to its retainer, making sure the client was aware that in essence what the firm would be doing would be the bare minimum of work to satisfy the retainer that was being proffered. The case is slightly unusual because the developer that was selling the property was putting the client and the conveyancers acting for the buyer under extreme pressure. And there was other issues about the quality of the expert evidence from the client that was suing the lawyers. But the interesting thing, and the thing that I've taken from this, is the fact that for once the court was saying that the fact that this was low-cost work, large volume work, was capable of justifying the lawyers involved, the conveyancers involved, limiting the scope of their retainer quite strictly. So it's a great case. The next case that I want to talk about is the case of AW Group against Taylor Walton. And again, as far as this case is concerned, again, it just relates to the issue of retainer and searches, and just reiterates what we said about Orient Field, namely this idea that you are required to report to client what a search reveals and also what should be done as a consequence of what is revealed. It also highlights the fact that you should be explaining to clients in your retainer letter the limitations relating to searches. And the fact I would maintain, because I'm very defensive with regard to conveyancing practice, that clients should be made aware that searches are from time to time defective. And in those circumstances, there is an opportunity to claim compensation from search provider, local authority, etc. The next thing that I want to mention is this case of Spire Property and Withers. This is really a really interesting recent case. We've just seen what the Court of Appeal has decided. And the significance of this case is, in my view, that what we have is again emphasis on the fact that during the life of a transaction, it is possible for the retainer to be extended or to be reined in and limited. In this particular case, what you had was a lawyer being asked about a position relating to some electrical cables after the transaction had been completed. And the important point here is the client was for saying, well, this was something, when we asked you this question, this was something that was within the scope of your retainer. Sort of harking back to the idea of, well, you've been instructed as a firm, not just for the transaction, but also to provide a sort of general counsel and the advice that we require relating to the transaction, even though the transaction is long concluded. And at first instance, the court was of the view that the lawyers were liable. On appeal, the Court of Appeal determined that the client was not to be successful and that the firm was able to successfully defend the proceeding. Now, again, the important point with regard to this case is that the fact that the lawyers had a robust and clear retainer letter clarifying the work that was going to be done was useful. The Court of Appeal made a number of interesting points. Where advice is sought outside the scope of the retainer, the issue for the court is, did a solicitor or conveyancer assume responsibility for the advice that was being provided? And the court said this is always going to hinge on the particular facts of the case, and therefore emphasizing and implying that where you are doing work that goes beyond the scope of the retainer, it is far better to clarify the position in writing rather than enabling the client to think, well, I'm receiving advice or I'm receiving explanation that's within the retainer, and the lawyer thinking that is not the case. So I've given you details about that case in the notes. I think the important thing here is that Spire and Withers is a case where you had a fairly sophisticated commercial client. Therefore, I'm not entirely confident that the stance of the Court of Appeal in this case would be the same as the stance of a Court of Appeal or a court at first instance in a residential case. But I just mention that case because it's a great case for just showing the fact that problems can arise where there is this vagueness or ambiguity as to whether or not the firm is instructed to give advice on a particular matter or not. The other thing that I've mentioned in the notes is a case called Turner and Bromett and Jackson Heath, a sort of matrimonial case where, again, client sues lawyers on the basis that you enabled me to enter into a tenancy in common that was disadvantageous. The beauty of this case from the defendant lawyer's perspective is, once again, they were very robust with regard to their retainer, equally robust with regard to advice that was given to the clients, and therefore they were capable of escaping liability. And before we finish, there's some other cases that I just mentioned in the notes that I'd like just to share with you before we finish. I've mentioned Rentokil Initial 1927 PLC and Goodman Derrick, which is a limited liability partnership, 2014 decision. And the beauty of this decision is, again, that the lawyers were arguing about their retainer and highlighting that the retainer was limited to legal rather than commercial issues, and therefore denied it had been negligent in drafting an agreement that was sort of peripheral to the transaction, but central to the commerciality of the transaction. Well, the important point with regard to this case is that, yet again, the judge was left with an exercise in saying, was this work within the retainer or out with it? In the end, he decided it was outside the retainer, it wasn't connected to the transactional work that the firm was undertaking. But the point that I want to make with regard to that case is that, again, this defendant lawyers were dragged through the courts before the judge was able to protect them by stating that what was being asked to be advised upon was out with the retainer. Even if it is out with the retainer, that doesn't necessarily mean that liability will be capable of being avoided. So to summarize then, with regard to today's presentation, what can we take from what we've said? Well, point number one, absolutely essential that your firm has a policy about what the retainer is in connection with residential transaction, that you highlight what the firm will do, you highlight what the firm will not do, and where work is to be done, if there are limitations relating to that work, that is clearly set out, so the client is under no illusions as to the potential risks associated with the conveyancing transaction. That you keep under review what the fee earner is doing during the life of the transaction, and that fee earners have to take responsibility for being able to acknowledge that the transaction is sufficiently peculiar, that things are being asked to be done outside the scope of the retainer, and therefore the retainer is being varied, and once again we're drawing lines as to what's being done and not being done. Where clients are intent in a residential transaction on getting involved in construction, alterations, planning issues, etc., that again we cut the client short and make sure the client is aware that we're not giving advice on those areas unless colleagues, etc., are indeed giving that advice, in which case separate retainers are necessary. With regard to reporting on title, it's perfectly proper and right to limit liability or restrict liability or exclude it, but that isn't the same as what we're saying with regard to the retainer. The report on title is not, in all the cases that we've looked at today, going to be sufficient to enable us to escape liability. It is the retainer that helps us or hangs us where there isn't a retainer and we don't have anything that enables us to determine what is to be done or not to be done. We are vulnerable to the client stating to a judge or our insurers, this is what I assume the conveyancer was doing. Stephen, I'm conscious of time, and what I'd like to do, if possible, is just see if there are any questions or queries, or if you or Robert have any comments to make. Robert, I know you've looked at the Withers case too. It is quite interesting, isn't it? And I think the important point to take from it is, first of all, to be careful when we're dealing with commercial transactions to make sure, again, that the client is aware of what the conveyancer is required to do. You know, is a conveyancer required to give advice relating to the removal of changing direction or location of cabling under a property? And then, of course, making sure that where clients are asking questions when a transaction has been concluded, making sure that what we're telling the client is right, or ensuring that if the client wants advice about the law relating to cabling, etc., or the moving of electrical cabling, that a new engagement letter, a new retainer is obtained from the client with regard to that additional work.
Yes, Ian, I think what the latter point there was an example really of the lawyer trying to help the client, was put on the spot and asked a question, and then I think in the case, as I read it, freely admitted that they didn't really know the answer. They had a vague memory from an article they'd read and gave that. So that's the danger there. The other aspect of Spire, which we haven't really looked at, is where they were held liable for not having done the proper searches on cables, high voltage cables. Yet their retainer letter in that case said all relevant searches or all necessary searches, which was such a vague wording that they were held that it should cover it. So it may be pedantic, but it possibly is necessary to list all the searches you're going to do.
Yeah, what I would do on the search front always is say to the client in residential transaction, these are the searches that my search provider is saying are available. These are the searches that I contend are necessary. Are there any searches, given what you're doing with the property, that you would like me to undertake? And I think if we adopt that strategy, Robert, we're going to circumvent the problem that happened in the Withers case.
Yeah,
great point. Stephen, are there any questions?
Yeah, thank you, Ian. We have just a couple. It's quite quiet on the questions front. Probably keep it open for a couple of minutes. Just as a reminder to everyone, if you would like to submit a question, you can do through the questions pane in the attendee control panel. There's a little box there that allows you to type the question out. Just a couple that we do have, Ian. David asks, do you think a client should be asked to sign a copy of the retainer to confirm that they understand?
Yeah, I would. I think it's wise, just to say to the client, sign a copy of this to confirm you've read it, confirm you've understood it. And then there's no debate, is there? That's the point. I would also say to the client, do you have any questions about it? I'd be far more comfortable talking to my professional indemnity insurer or sitting in front of a county court or a high court judge where this issue or a problem arises and being able to say to the judge, well, I sent it to the client acknowledged receipt of it and confirmed to me that they read it and understood it, and I asked them if they had any questions about it and they said they didn't. So I think that gives you loads of potential ammunition to defend any claim that's brought at a later date where the client turns around and says, well, hang on a minute, I missed this, or I didn't get the significance of what you're saying. Because you can turn around and say, well, if that was your stance at that time, I invited you to ask a question or to confirm to me that there were issues or problems with your understanding of the documentation. So in short, I think it's a good idea. Yeah.
Fantastic. Thanks, Ian. Thanks, David, for that. Another question we have, Ian, and it's slightly different. We have spoken about things like precedent documents and things like this before in previous webinars. But the question is, do you think you need a retainer for each transaction, or can you have a general retainer for all jobs where you have a regular client?
Yeah, I think you can have a precedent retainer, but I think what you've got to do is you've just got to bear in mind, as I've tried to give examples this morning, of situations where the retainer needs changing because of particular circumstances. So the one I've given you, I instruct you to act for me on the purchase of a property. I tell you that I'm going to be submitting a planning application in connection with the building of a granny annex, and I'm also having builders looking at pricing the job and drawing specifications up, etc. In that situation, I'd be saying to the client, in my retainer, I will not be giving you any advice relating to the construction work or planning issues that you've discussed with me or explained that you're going to do. That sort of thing. It's just, I think the point here, Stephen, is that we're making sure that we're clearly drawing a line, and so that the client and we know, and for future, a court or an insurer knows that we're not giving any advice relating to it. I think where the Withers case comes in is what happens if the client then asks you for some sort of off-the-cuff advice about, say, a construction contract or about a planning condition. And in those circumstances, you've got to make sure that you are, if you're going to give advice relating to that, that you are varying your retainer, or that you're saying, I'm not giving you advice. And again, just reiterating that there's a retainer telling the client precisely what you're doing and precisely what you're not doing.
Yeah, perfect. Thank you, Ian. We have a few questions flying there, so I'll try and get through these quickly if I can. From Amy asks, she makes a point actually, because we were talking about this with Robert, but it's often too early to know exactly what searches you need at the retainer stage, so you may be generic in the scope. Do you have to go back to the scope doc stroke confirmation of instructions on that list once it becomes apparent?
Yeah, I think if you've set out to the client the sort of searches that you generally do, and then you ascertain that some of those searches are unnecessary, I would be reporting to the client that fact. And again, I think, unlike what Amy has said, my philosophy is tell the client about all the searches that are available from your search provider, tell the client the searches that you consider are necessary, but then say to the client, these are the other searches that could be done. Is there anything else that you'd like us to investigate? So you're putting it in the client's hands. Now, all right, there's a danger that the client says, well, I didn't know that you could, I didn't know what an infrastructure search would reveal. I'm not aware of what an infrastructure search is. Do you have to tell the client about what an infrastructure search would produce? I don't think you do. I think you say to the client, these are the searches that are available. Are there any of those searches, or is there anything that you would like us to investigate in connection with the purchase? I think as long as you've done that, you're all right. Again, remember, the test is, what would a reasonable conveyancer do? And a reasonable conveyancer is not going to give the client a full-page report about every conceivable search that could be undertaken relating to a property. But I think saying to a client, these are the searches that I'm going to do. Here's a list of searches that I could do. Can you tell me if there's anything that you need to know about this property? And then I will determine, or I will explain to you for any searches that will reveal the information that you require. It's sort of that sort of step, if you understand, Stephen.
Of course, yeah. Okay, perfect. Yeah. Thank you, Ian. Final couple of questions then. One of them quite interesting, but Victoria asks, when extending or revising the retainer, should this be by way of an amended and signed client care stroke retainer letter, or is it sufficient to extend the stroke limit in other written correspondence, e.g. letters and emails?
That's a great question, Stephen, and I would say an exchange of emails would be sufficient.
Perfect, thank you. And the final question I have is from Ali, and thank you for that, Victoria, as well. And Ali asks, what is your view on lawyers being responsible for advising clients on climate change?
I was just about to interrupt you, Stephen, and say, let's talk about climate change for a moment. Right. Yeah. There is an opinion from a QC that said potentially you could be negligent if you fail to advise clients about climate change. I would, at this juncture, limit my retainer to say that I will not be giving any advice to a client about climate change risk. I think it is good practice to say to client, there are searches out there that can give indicators as to climate change risk in the future. But again, I've done a number of training events for search providers that now offer climate change searches, and I think it's important that we make sure clients are aware of their availability, but that we make sure that clients understand we're not in a position to give advice relating to them. Very interesting question this, Stephen, because someone said to me, well, hang on a minute, when I was doing a webinar on climate change, and they were saying to me, well, hang on a minute, it's not necessary to do a climate change search or advise a client about it, because, you know, climate change might be 5, 10, 20, 50 years hence, and, you know, we can't really crystal ball gaze. And I was thinking about that on the evening of the webinar, and then I thought, well, hang on a minute, in a leasehold transaction, we're telling clients about ground rent reviews that are 10 years hence, 20 years hence, and warning clients about them. And we are warning clients about issues relating to things like rent charges, state rent charges, etc., which potentially can bite or potentially have a sort of an ongoing nature. And, you know, who would have said 50, 60 years ago that solicitors would be sued for not giving clients advice about things like chancel repair liability? Who would have thought 50, 60 years ago that solicitors were being sued or being held liable for not recommending to clients environmental searches and reports? So I think the issue of climate change is going to creep up on us. And my view is, at the moment, you say to clients, there is a search that I can undertake on your behalf. Do you want me to do it? So again, it would be one of those things that in my list of searches that I'm saying are available, I might highlight to the client and say, do you want it? But I don't think
thank you.
You should be limiting your retainer so that you're not, you obtain the report for the client, but you can't give advice on it. Obviously, that would be the thing. That's a great question, by the way, Stephen, and I think that's something. Climate change reports are going to be something that we'll discuss, I think, in future webinars. Again, you know, just looking at this issue of searches and just looking at what the future holds relating to searches, because there's no doubt in my mind that climate change obviously is a massive issue anyway, but will become more and more significant in conveyancing, because, you know, 5 years, well, perhaps even less, the way people are talking at the moment, 5 years, 10 years time, we might find situations where our property is unmortgageable or unsaleable because of climate change issues. And at that point in time, someone may turn around and say, well, I bought this property in 2022 and my conveyancer didn't tell me, or I wasn't aware that a climate change search report or search was available that would have highlighted this risk and perhaps encouraged me not to buy this particular property. Great question, that one.
Yeah, absolutely. Thanks, Ian, and yeah, thanks, Ali, for the question. I think we'll wrap it up there. Thank you to everyone for questions. There were some great questions there, and thank you to everyone for attending today's webinar.
Yeah, thank
if
you.
you do have any other questions, then please do contact Ian or myself. Once you leave today's webinar, you will receive an automated message from GoToWebinar. If you respond to this email, the replies will come directly to me, and I can either respond or send any questions or feedback on to Ian. You will also receive a separate email from my colleague Robert Kelly, which will contain the slides and notes to today's session. And please look out for our next webinar. I believe we will be hosting one in October, with details to be confirmed, to look out for that. And just on behalf of myself, Stewart Title and Ian Quayle, thank you very much for joining us today, and have a great rest of your day. Thanks, everyone. Goodbye.